Yes, good afternoon to everybody. Welcome to the today class. The Transfer of Property Act. We are dealing over there. The first unit is almost all over. Then I started, not the first unit, the middle of it is going on over there. Then we'll see that what would be the next. Because we did it, the modes of transfer, the operation of the transfer. Then in this class, as per the syllabus it is concerned, that we are dealing the condition precedent and condition subsequent, or we can say the conditional transfer is concerned. Of course, it goes with the wide and unlawful conditions also. Later on, they will see the vested and contingent interest. So now in this class that we are going to deal the conditional transfer. Yes, welcome it. Then I'm sure that the people are joining one after another. Even one student also there. My class will be as usual as I promised earlier. So that the conditional here, what are the conditions should be there for the transfer is concerned? Let us see the conditional transfers. Yes, are you hearing me? Just you say that I want to get the confirmation from you. Yes, are you hearing me?
Yes, sir.
Very good, very good. So now I can proceed it without any hesitation. Yes, conditional transfer under the Transfer of Property Act 1882. So introduction, it says with the section 25. Section 25 of the Transfer of Property Act 1882 provides for a conditional transfer. It means that any transfer that happens on the fulfillment of a condition that is imposed on the other party for the transfer of the property. For example, A agrees to transfer his property to B. I repeat, A agrees to transfer his property to B if he gets selected for a job. So the condition is if he gets selected for a job, then the transfer is a valid transfer. The requirement of the A for the B to get a job is called a condition. So getting a job is a condition. If he did not get the job, he did not get they did not receive the transfer of the property. So that is the condition is there. So for any kind of a condition transfer to be valid, so the condition that is imposed should not be they given the under there are many other things which are given over there. Mm. Yes, the condition which I put it over there. Number one, prohibited by law. Yes, if any condition is there which is prohibited by law, then the transfer is not a valid transfer. The second point is should not be an act that involves fraudulent acts. Yes, if there is any fraudulent act would be there, then the transfer of such a thing is not a valid transfer. Third, should not be any act that is impossible. Yes, that if you put the condition like the condition you put it over there, if you walk in 1 hour 100 miles, then I will transfer this property to you. So, can a person walk 100 miles in an hour? Anyone? Give the
No,
answer.
sir.
Oh, why? Because 1 hour 100 miles is not a possible. So that condition is impossible. So keeping such a condition is the transfer is not a valid transfer. That is the third. The fourth one is should not be an act that is termed as a violative of public policy. If any act which is violative of the public policy would be there, such a condition that you will put it, then it is not a valid transfer. So condition should not be immoral. Again, the condition should not be immoral. Such a condition is not valid. Then the transfer is not a valid transfer. Then any act that not valid transfer, no more transfer at all. So any act that incurs any harm to any person or his property, yes, even a person keeps such a condition, yes, at that instance also the condition is not a valid condition, hence the transfer is not valid ab initio, we can say. So example, we can say that X transfers the property B. Here the property is B to Y, stating that he shall murder Z. Who had to murder Z? The Y has to murder Z. If you murder Z, he will get the property B. From whom? From A. So Z has a condition that murder shall be Z. Murder to the Z is a condition for the transfer. Such transfer is void as the condition is prohibited by law. Prohibited by law. So can a law will allow a person to be murdered? So answer is
No, sir.
no. So that is the thing. So when anything which is prohibited by law, and if a person keeps such a condition, so such a condition is void, and transferred is ab initio y. Now let us see the types of the condition for transfer. On transfer, what are the types of the conditions that will be there? So it is clearly mentioned there are three specific types of conditions that are imposed in a transfer of property, and there are some more types provided also. A little difference would be there, it's a condition, but generally in our syllabus we will find conditional precedent, conditional subsequent. But anyway, that the time is there, then we can test the other conditions also, which are said to be the collateral conditions. Yes, all these conditions should also satisfy all the requirement of the condition as mentioned in the section 25 of the Transfer of Property Act 1882. So now these are the condition which is put over in the section 25 of the Transfer of Property Act. What are the conditions? We will see it now. So in a condition precedent, so we will see what is the condition precedent. Pre means anyone? Pre, pre. Yes, what it means by pre? Pre. If you know it, you can.
గుర్తు రావట్లేదు సార్, గుర్తు రావట్లేదు.
Pre-term examination అంటే before examination, pre-schooling, before schooling.
ఓకే సార్, ఐడియా వచ్చింది.
ప్రిఫిక్స్ ముందట వచ్చింది, సఫిక్స్ వెనక వచ్చేది. సో ద ప్రీ మీన్స్ దట్ విచ్ విల్ కమ్, ద కండిషన్ కమ్ ఫస్ట్. Yes,
namona.
Yeah, pre not namona actually. Pre means anything which come first. First condition should be fulfilled, then the transfer will be valid. So that is called condition precedent. So it is given in section 26 of the Transfer of Property Act 1882, the condition precedent. Any condition that is required to be fulfilled before the transfer of any property. So first the condition should be fulfilled, then the transfer will be take effect. That is called condition precedent. So transfer, before a transfer of property, the condition should be fulfilled, and that is called condition precedent. This condition is not to be strictly followed, and the transfer can take place even when there has been a substantial compliance of the condition. So not necessarily if the 100% condition should be there, at least 75% conditions also fulfilled over there, then it is a valid transfer, or one should have to say that it is a valid transfer, and it will be, that property will be transferred automatically. For example, we will see that what is that this condition totally or condition substantially. Yes, fulfilled over there. A is ready to transfer his property to B. Okay, good. Who is ready? A is ready to transfer his property to B on the condition that, what is the condition they put it over there? That he needs to take the consent of X. So first he has to take the consent of the X, that the precondition should have to be there. And he has to take the consent of X, comma, Y and Z. So he has to take the consent from the three persons. Who are the three persons? X, Y and Z. Before marrying. So before marrying, that he has to take the consent of the three persons, and then only he can transfer the property to B. And among the A, X, Y, Z, Z dies, and afterwards B takes the consent. So Z dies before he is married over there. So Z consent is not taken over there. Then whose consent is taken? Then X and Y. Let us see that. If Z dies afterwards, B takes the consent of X and Y, so the transfer can take place as there has been a substantial compliance. These facts were from the case of the Dawson versus Oliver Massey. So the facts of the thing is condition precedent, even if it not be 100% fulfilled over there, at least substantially means 75% also fulfilled over there, then the contract is valid, I mean transfer is valid. Like A has promised to marry the some X so and so person, but then only he will transfer the property to B. But before the marriage, he has to take the consent of the X, Y, Z. But meanwhile, Z died before he is taking the consent. Then he took the consent of the X, Y, later married. Then at that time, the A has to transfer the property to B because substantial conditions are fulfilled over there. Instead of three people consent, two people have taken it, then it is said to be a substantial. That is the case law which is observed in the Dawson versus Oliver Massey. That is the case law. So in the landmark case of the Wilkinson versus Wilkinson, this is another case law, which is said to be the landmark case law. The condition where one party was required to desert her husband for the transfer to go through. This was held by the court as invalid as it was against the public policy. So now here in this Wilkinson versus Wilkinson case law, what did you understood? Yes, anybody? What did you understand in the Wilkinson, the case law, which is there on the screen? Yes. Anyone unmute and give the answer to my question, which is on the screen. That is in the landmark case of the Wilkinson versus Wilkinson. I am sure that you could see it and you could read it.
Yes,
Yes,
sir.
anyone can read?
So in the landmark case of Wilkinson versus Wilkinson 2, the condition where one party was required to desert her husband for the transfer to go through. This was held by the court is invalid as it was against public policy.
Yes. How
So
much that you understood?
condition number 140.
Okay, I will give the answer for that one. So what is that? One spouse had to desert the another spouse. Means either wife has to desert the husband or a husband has to desert the wife. If the desertion take place, then the court, they said, it will be the valid, they will say. But desertion, keeping such a thing which is against the public policy. Here desertion means leaving the husband from the conjugal rights. So either by the wife or by the husband, if such a condition would be there, which is against the public policy, that is the case law. Is it clear? If not, yes, I will repeat.
Sir,
What is the
మళ్ళీ repeat చేయండి.
yes? What is the case law? Condition. What is that condition? Where one party, and one party means anyone, spouse. Spouse అంటే ఎవరన్నా కావచ్చు. Either wife కావచ్చు or husband కావచ్చు. So if the wife deserts the husband or husband deserts the wife, అంటే వదిలిపెట్టడం, desert అంటే ఇక్కడ వదిలిపెట్టడం, నో బీబీసీ, నో కాంజుగల్ రైట్స్. సో అట్లాంటి వదిలిపెట్టి డెజర్షన్ చేస్తే such a transfer is a valid if such a condition is put there. Then the court observed there the condition which is invalid because it was against the public policy. It is against the public policy. That is, so desertion is not allowed over there, and a desertion is not a good act also. So that is the thing which will observed in the Wilkinson versus Wilkinson case law. That is about the conditional precedent. Precedent means the condition should be fulfilled first, later on the transfer will take place later. So now we'll see the condition subsequent. So here the condition is subsequent means later. So how it can be made, that is clearly given in the section 29 of the Transfer of Property Act 1882. So what is the condition? Any condition that is required to be fulfilled after the transfer of any property. So first the transfer take place, after that one the condition should be fulfilled. So that the property is called condition subsequent. This condition is to be strictly complied with, and the transfer will happen only after the completion of the such condition. For example, we'll see it. A transfers any property X to B. Here the property name is X that A is transferring to B. On the condition, what is the condition? That he has to score above 75% in his university examination. So that is condition that he has to score the above the 75% in the exam and in the university examination. So if B fails, suppose B fails, to whom that father is going to give the property to B, and if B fails to achieve the 75% marks, then the transfer will break down and the property will revert back to A. Then he need not to pay the property to B. So because the condition subsequent is not fulfilled over there. See, after getting the result only he came to know that he will pass or he will fail. But merely getting with the rush, early was knowing it, that much not the wasteful, that will not be encouraged over there. And at that instance, we can say that condition subsequent, then it is not fulfilled over there. At that instance, one cannot get anything. The transfer will not take place. So that is the condition subsequent. So here the subsequent condition means after 75% attendance is more important. Although it is an essential requirement that the condition need to be lawful, and if it is not, then the condition will be held void and the transfer will not break down and will be finalized. So whatever the condition that you put it over there, that it should be lawful. So then only it will be worked over there. That to be in some certain circumstances. For example, A transfer the property to B, very good. Why he transfer it? What is the condition of a transfer? Yes, on the condition that he shall murder C. So if you murder C, then A transfer the property to B. So, murdering is allowed in the law. Anyone?
No, sir.
Not at all. So, this is the condition is wide, and hence transfer will grow through and the property will be kept by B. So, they will check the condition whether it is proper or not. Then, if it is proper, then the transfer will be take place. If it is not proper, the transfer will not take place. That is the thing which is then a subsequent. So we have studied the condition precedent, condition subsequent. Now we will see the condition collateral. Yes. Any condition that is required to be fulfilled simultaneously after the transfer of the property is called condition collateral. The simultaneously, if any condition would be there that will be fulfilled, then such a condition is collateral conditions. It needs to be strictly followed, otherwise the transfer will break down. For example, A transfer property X to B, it's good. X property he wants to stick A transfer the property to B property of the X. Yes, it is such a conditional, and otherwise the transfer will break down. Suppose if we did not do so, the transfer will break down. Example, we will see it. A transfer of property X, a transfer of property X to B on the condition that he shall maintain A's wife C for a period of 10 years. So he has to maintain the A's wife C for a period of 10 years. Then the property X will be transferred to the B. If B complies with it and maintains C, the transfer will be valid and the property will be in the possession of B. Suppose if we did not do so, then the property will go back to written by the A itself. So also it has been recently clarified by the Honorable Supreme Court in the case in 2018, in case of the conditional gift, where there was no recital of the acceptance and no proof or any sign of the acceptance, if the position of that gift is with the donor for his lifetime and it is not completed during his lifetime, the deed of gift might be cancelled. And the option of the donor, as it has not been violated any principle regarding valid transfer of property. And the donor is within the right to cancel any gift or deed of such a kind. So, conditional precedent, conditional subsequent, condition collateral also be there. So, these are the conditions generally that we will study. Then other types of the conditions, it is given in the section 27 of the Transfer of Property Act 1882. But as per our syllabus is concerned, we will restrict to only the conditional precedent, conditional subsequent. Later on, one more condition is there, but that condition is a bit different from what we are studying now. So let us see what are the other conditions as per the syllabus is concerned. Yes, as per the syllabus is concerned, we have the conditional transfer where we can say condition precedent and we have read the condition subsequent. Then we see what is the wide and wideable conditions or what are the other type of the what I say conditions are there. We will see. So in this yes. So other types of the conditions, that means section 27 of the Transfer of Property Act 1882 provides for any transfer to any other person. I repeat, it provides for any transfer to any further person if the first transfer fails. Suppose the first transfer fails, can in seconds transfer he can make it or not. For example, A transfer a car to B, well and good. The car is transferred to B, and B on condition that he shall transfer his bike to C. So if he does not the car, if he does not do it, shall go to C. The car goes to C. Then it goes to, shall go to D. Sorry, not D. So if B dies, B does not transfer his bike to C, the car shall go to D. So, on failure of the prior disposition, as said in the section. Suppose if it is transfer, it goes to B. If it does not transfer, it goes to D, whichever is there, as per the condition kept it over there. If it transferred, it goes to somebody else. If not transferred, it goes to somebody else. It is said to be the other type of the condition. So, it should not be noticed that the condition on the first transfer was valid, otherwise the subsequent transfer or transfer fails. So only when the valid condition is not fulfilled and or shall fail, then only the subsequent transfer take effect. So that is a validly either to do or take effect or not to take effect. Clearly it should be made. Then only it goes to the secondary point. Of course, we did not see the doctrine of acceleration in our syllabus, and that's why we can eliminate here, or just we can throw light on the doctrine of acceleration. What is the doctrine of acceleration? So, what doctrine of acceleration come into the picture here? It is based on the principle that one party should be passed on to some other person if the first condition fails, as if the property was never vested in him. So let us see the one of the case law so that we could understand what actually it says. There is the Ajudhiya, that is the case law. Ajudhiya versus Rahman Kaur, where the property, when not registered in the name of the mother. So I repeat, the property when not registered in the name of the mother because of the local act would not allow it to register on the mother, and she could not have received the gift. So when there is no such a transfer, then naturally she could not have received the gift. The property was assimilated to the children as a gift. At that instant, the property goes to the children as a gift. So here what I want to say is, if the property when registered in the name of the mother because of local act, and she could not have received a gift. So the local act will not allow it to be registered on the property. Then he should have not have received the gift. Of course, she will not get any gift, or she will not get any transfer. The property was assimilated to the children as a gift. So when is incapable of taking the property by the local laws, then the property goes to their children. That is called doctrine of acceleration. So there is an exception to this section. Of course, every rule have its exception, because in a transfer from a form of a gift, doctrine of acceleration does not apply unless the first transfer fails in a particular specified manner. So first one is the first transaction should not be valid. Then only the second transaction will be accelerated. Here the case law, the first transfer means the local law will not allow it to transfer on the name. Hence, the property goes to the children. That is called doctrine of acceleration. I don't know whether you got my point or not. Anyone? Yes? What did you understand the doctrine of acceleration?
ఫస్ట్ కండిషన్ ఫుల్ఫిల్ కాకపోతే ఆటోమేటిక్గా సెకండ్ కండిషన్కి వెళ్తుంది అని.
Yes, when the first condition is not fulfilled over there because the local law did not allow to be registered on her name, then the second thing automatically it is accelerate, the property goes to the children. So that is the doctrine of acceleration. So now section 28, let us see section 28. The Transfer Property Act provides for any subsequent transfer that takes place or not happening of a specified event. Yes, not happening of a specified event would be there. then the transfer will take place. Let me see the conditional limitation. What is the conditional limitation is there? Is something that is applied here, it affects any ulterior disposition. If a vested property involves any condition that does not happen, it takes place and property is transferred to the ulterior disposition, which is the ultimate beneficiary. So if a condition is not happen over there, naturally the ultimate beneficiary will get the property. So the section is, of course, they made the section is subject to certain rules. That is section 10, 12, 21, 22, 23, 24, 25, and 27 of the Transfer of Property Act. Of course, these are all the restrictions we put it over there for such a transfer. For example, we will see in a contingent interest, which is mentioned in the section 21 of the Transfer of Property Act 1882, then the condition is put that A's land, I repeat, the A's land which is transferred to B, okay, will be transferred to C, okay, if B dies. So A's land which is transferred to B and will be transferred to C if B dies. Of course, when the B dies, automatically the property which is supposed to be transferred to the B, when the B dies, it goes to the C. It will be clearly written over there. Hence, the interest created in the C is ulterior transfer. The ulterior interest is created over there because the condition is not fulfilled. Then the ultimate beneficiary is the C. So this argument, the requirement here also that the condition need not be lawful and satisfy all the requirement in section 25. So naturally, how he got that is not taken into consideration. Position is a very important factor. Hence, position is the 100% ownership also we can say. So now let us see what is the section 30 of the Transfer of Property Act 1882 says. So it provides that any transfer will not be affected by the invalidity of the ulterior disposition. So I repeat, it provides that any transfer will not be affected by the invalidity of the ulterior disposition. They say invalidity of the, which means that that is the subsequent transaction as it is rendered void because of some default, and then the first transaction will not be held invalid because of it. Because the second is made invalid because of the default, but first may not be dissolved over there because said is the default, and here also we cannot presume that first transaction also such a nature. Example, we will see that if X transfer land to Y, okay, so transfer to Y, X some land. Of course, land, nature of the land is not given. So, X transferred land to Y and then after his marriage, life interest to his male offspring. So now the question comes, and then after his marriage, whose marriage? Yes, if his marriage, the life interest to his male offspring, then after his marriage, if he dies over there, life interest goes to the children. As the transfer to the male offspring is not valid as per section 13 of the Transfer of Property Act 1882, which prohibits any life interest. If there is a life interest, it will not be taken into consideration. And created in the favor of the unborn. So if the unborn person favor also they married, which is not in existence, then it cannot be counted. The substance of the section 30 provides that the transfer to B will not be affected. It will not be affected even when the ulterior disposition transfer to unborn son is not valid. So whatever that unborn son is not valid over there, but still the will not be affected. So they say it doesn't have any effect because the ulterior motive is failed to make it out. So that is the say about the section 30. Then we'll see what is the section 31 says. And when you come to the matter of the section 31, it says that any transfer, okay, where the condition of happening of an event or not happening of an event takes place is applied, the transfer shall cease to have an effect. So suppose happen not to happen, if it is made it over there, and if any person will get the benefit, that cease to be such a benefit. So that the transfer cease to have an effect. That is the meaning. The condition mentioned in this section is a condition subsequent. Your subsequent activity is there, and not a conditional limitation which is in favor of any third person, or there is no conditional precedent here. So this condition is given in a negative sense. So as the transferor prescribes when the transferor shall cease to have effect. So again, we will say that when the effect would be there, when the prohibition will become so there, when the prescribedness would be there, will be clear shown in this section 31. Let us see one example on the section 31, where it says A can put a condition on B. So A keeps a condition on B and to plant a tree, then the transfer will have an effect. So if you planted the tree, then only the transfer will be having the effect. And if B plants, then he will get the property. Suppose if B plants over there, as per the agreed terms and condition, of course B will get the property of his own share. But if he does not make it out, he himself made it over there, then the growth would be less. Then you will be relieved from the burden. So what I want to say. So even where the condition, where there is a prescribed penalty, it can be extracted by way of compensation. For example, for forfeiting an estate, compensation can be demanded. Suppose if a person is forfeiting the estate because it is by land acquisition or by any other means, the government has taken it. At that instance, the person who is a victim of the plant, he should be compensated. So that is the said in the section 31. Of course, there are section 32, 33, 34 are there, but those are the meager sections, and we have only the condition precedent, condition subsequent, condition collaterals. So these are the three things as far as our syllabus is concerned, but still we can touch the section 34 of the Transfer of Property Act 1882, which states that about any transfer where on a condition time is specified for the happening or non-happening of an act, and on the failure of such a condition, the interest of the property is to go to the another person. So if the condition is fulfilled within the prescribed times, then the transfer will continue to live effect. And if not, then then the transfer shall cease to have an effect. So let us understand by the one of the example which is given here. M agrees to transfer land X to N. The land name is X. Transfer to whom? N. Who is the transferor? M. Transferee N. Subject matter X. Land. Yeah. On the condition, what is the condition they put it over there? On the condition that he shall go to England in a span of 2 months. So he should have to go to the England in a span of means the period of 2 months. Can a person will go on foot to England on foot? Yes.
Sir, no, sir.
So if M agrees to transfer land X to N on the condition that he shall go to the England in a span of 2 months. If N goes to England within a prescribed time period, then the transfer shall go through the N and shall get the property. But if he fails to do so inside the 2 months specified by M, the transfer shall cease to have an effect. So if a condition is fulfilled, he will get it. If the condition he did not fulfill, he did not get it. So that is the stated in the section 34. And but it has been seen that what caused the delay of the condition. Of course, we will consider who caused the delay. Suppose if we intentionally cause the delay, then the condition will not be valid condition. Of course, the contract will be allowed. So let us see that if we intentionally cause such a such a delay is concerned. If the performance of the specified condition that may be either subsequent or precedent is prevented by a person who is interested in its non-fulfillment, the delay is condoned and the condition is discharged. Suppose if they intentionally made it, then the delay will be condoned and the condition will be discharged. Let us see with the example so that we could understand whether the delay is caused by any one or by any other means. So X transfer property to Y. Okay. Who transfers? Who is the transferor? Who is the transferee? Tell me.
X transferer, Y transferee.
Very good. X transfer the property Y. Okay. With a condition. What is the condition? That if he does not go to US, if he does not go to US within 2 years, the property will pass on to Z. Who Y will not go, does not go means will not go to US within 2 years, the property will pass on to Z. Later on, if Z by playing a fraud, later on what is that? Later on, if Z by paying a fraud prevents Y from performing the condition, the delay in such a performance is excused. Yes, now you tell me why it is excused. Anyone? Yes? Why it is excused? Tell me, anyone. Yes, unmute and give me the answer. Because here, please say pass on. I will give the answer.
సార్ మరొకసారి అనేసి.
X transfer property to Y. Okay. Y కి ప్రాపర్టీ ఇస్తాడు. With the condition that if he does not go to US, US కి పోకపోతే ఎప్పుడు 2 years లోపట the property will pass on to Z. అంటే Y 2 years లోపట పోకపోతే ప్రాపర్టీ Z కి వెళ్ళిపోతుంది. లేటర్ ఆన్ ఇఫ్ జెడ్ ఏం చేస్తాడు, వాడు పోకుండా చూస్తాడు. ఎందుకు పోకుండా చూస్తాడు? వాడు పోకపోతే ప్రాపర్టీ వానికి వస్తుంది. లేటర్ ఆన్ ఇఫ్ జెడ్ బై ప్లేయింగ్ ఎ ఫ్రాడ్ ప్రివెంట్స్ హూమ్ వై ఫ్రమ్ పెర్ఫార్మింగ్ ది కండిషన్, అంటే డిలే చేస్తాడు అన్నట్టు. ఆ డిలే చేస్తే 2 years అయిపోతుంది. ఆ డిలే చేసింది కాబట్టి ప్రాపర్టీ జెడ్కి వస్తుంది. ఎందుకు? జెడ్ ఇంటెన్షనల్లీ డిడ్ ఇట్ బై ఫ్రాడ్. సో ద డిలే where the Z has made intentionally, and hence the Z delay of such performance is excused. అంటే ఆ డిలే చేసింది
కావాలని
చేసిండు,
సార్
వానికి రావాలని చేసిండు, కావాలని చేసిండు, రావాలని చేసిండు. ఎందుకు? వాడు పోవద్దని. వాడు పోకపోతే
ప్రాపర్టీ వస్తుంది కాబట్టి.
అది సంగతి. అటువంటిప్పుడు ఏమవుతుంది? డిలే కెన్ బి condoned, excused. So these are the minor thing is there, like a doctrine of acceleration, and delay will be condoned. Ulterior motion, either is a condition subsequent or condition precedent, whichever it may be. So that was the thing which is there. In conclusion, we will see what conditional transfer from a very crucial aspect in day-to-day transactions of transfer of property. So it is important to know that about the provisions relating to this concept. All types of the conditional transfer are given from section 25 to 34. It is clearly mentioned, section 25 to 34 of the Transfer of Property Act 1882. It is important to note that the condition on any transfer shall not be prohibited by law. Yes, it should not be prohibited by law, and can be ideally performed. It should not be an impossible thing. This paper or article conveys the basic principles and mechanism behind these provisions and how they fare out with the practical examples that will help the reader relate it with the real-time events. So what is the condition? Whether the condition is a valid condition, whether the condition is prohibited by law, whether the condition is against the public policy. So these are all the things which is given over here. Like the first one is the prohibited by law. The second one should not be an act, involves the fraudulent acts, fraudulent చేయొద్దు. And third one, it should not by any act is impossible. Then we cannot make it is impossible also. At that instance, then the fourth one should not be an act that is termed as a violative of the public policy. So the condition should not be against the public policy. The fifth one should not be immoral. There should not be immoral act. And the sixth one, any act that incurs any harm to any person or his property. So if you, can I make a contract A wants to transfer his house to B. Okay. On the condition that the B should have to beat C till he becomes handicapped or till he becomes died. Can you put such a condition?
No, sir.
This is beating is prohibited by law. So why you should have to beat him? Sir, if he beats him, he will get the property. But if you beat him, is it not against the trespass to another person? Yes, it is a trespass. Then if anything trespass or illegal, we are not supposed to perform it. సపోజ్ ఏ బి కాంట్రాక్ట్ చేసుకున్నారండి, ఏముంది పెట్టిండ్రు, అరే దొంగతనం అయిన తర్వాత అవి మనం సరిసగం పెట్టుకుందాం. కండిషన్ ఏది దొంగతనం అయిన తర్వాత అంటే కండిషనల్ ప్రెసిడెంటా కండిషనల్ సబ్సిక్వెంటా? పంచుకునేది ఏదేమో సబ్సిక్వెంట్ అవుతుంది, దొంగతనం ఏదో
సబ్సిక్వెంట్
ఎందుకంటే పంచుకోవడం అనేది ఎప్పుడు జరుగుతుంది, దొంగతనం అయిన తర్వాతనే కదా. So if the condition is the subsequent or condition is the precedent, is an illegal act. దొంగతనం చేయడం అనేది ఇల్లీగల్ యాక్ట్ కాదండి?
Yes, sir.
So all those things which are come under the 1 to 6 point which I mentioned over there, section 25 to 34 of the Transfer of Property Act, which all said about the conditions. So either you can say condition precedent or condition subsequent or condition collateral. In any manner, if it is there, it is a valid condition, then it is okay. It is invalid condition, it is not a transferable. It is a void. The transfer becomes void. Can you give me one example for the valid condition, one example for the invalid condition? Yes, can try. Anyone? Anyone can try. Valid condition, if you pass, you will get the transferred valid condition. Okay. If you don't walk 100 miles per hour, that means impossible thing. So invalid condition. Are you following me?
Yes, sir. Impossible అనేది కానీ కండిషన్ అనేది వైడ్ కండిషన్.
అది వైడ్ కండిషన్ ఇంపాసిబుల్ కానివ్వండి, అది ఇల్లీగల్ అని కానివ్వండి, మోరల్లీ నాట్ గుడ్ అని కానివ్వండి, పబ్లిక్ పాలసీ
ఆల్ ద 6 points
which will, yes, the 6 points which will cover over there, those are not valid transfers and void transfers, we can say. So this is the thing. Today we dealt it, and tomorrow class what we are going to do is, because we conditional transfer we did it, we will see void and unlawful condition. Of course, some becomes void also, unlawful conditions also it will come over there, because if it is a condition is unlawful, it become a void. If the condition is valid, it become a valid condition. Tomorrow class we will see vested and contingent interest. Then with time left over there, the transfer of unborn person. So vested interest and contingent interest, we will see. If the time permits, then we can see the unborn person. In the tomorrow class, the class will start exactly 3:15, and try to pass on the information to each and everybody. And unless until there is a change, then only I will intimate you. If not, I will send the reminder. Thank you very much for patient listening. So let me stop here and have a good day and goodbye. End of my end meeting.